Hello, gentlemen. It is my pleasure to welcome you to this webinar. And may I first and foremost appreciate and congratulate the association for organizing this webinar, especially the president, the vice president, especially, of course, the vice president, academic and training, Ms. Chinyere, that have been in touch with me all this while. I want to assure you that if you listen very carefully and follow us here, we're not going to regret the time we devoted for this particular webinar. And I want to say that my specialization, actually, I am a professor of medical law and ethics of the University of Abuja. So I'll be back for us to take the lecture. Okay, welcome back. We'll go straight to the lecture now. I have chosen or taken the liberty to choose the topic of today's lecture to be the legal and ethical status of the patient under Nigerian legal system. I have decided to speak on this area because as lawyers and lawyers to be, we are more likely to be confronting patients in our practice or through our lives. And again, like I keep telling my students, all of us are actually patients. It is whether we are patient yesterday, or we are patient today, or we are patient tomorrow. So even if we are not in the hospital or patient today, we are all potential patients because of our nature as organic beings. So it is in our own interest as lawyers and lawyers to be to actually know the legal status of patients, especially in Africa and in Nigeria in particular, given the background and the fact that in Africa, many educated people, university professors, even doctors themselves, don't even know what a patient means, let alone realizing that patients have some rights under the law. And even we lawyers and our relatives, we need to know this because we are standing in a special position in our families, in our communities, and wherever we find ourselves, and we may be in a position to assist somebody who is a patient and whose legal rights and fundamental right to his right as a patient may be infringed or impinged upon one way or the other. So we move straight to identify or explain what patient means. The word patient derives from the Latin word patio, which means sufferer or sufferer. It is often used to describe any person who is receiving medical attention, care, or treatment, whether by way of illness or by way of injury. In law, the word patient actually depicts and describes a special legal status of a person who is in a special relationship with a doctor, a team of doctors, other healthcare personnel, or a hospital by reason of the need for the restoration of his health or to assuage his pain or suffering. This relationship may be created by contract or simply imposed by law. What we mean here is that it's not everybody that is sick that is a patient. If you are taking care of your sister in the house or your brother in the house, you go to buy malaria drug for him or go and buy pain relieving tablet for him or her, that you cannot tell your friend that I'm rushing home to go and give my patient this drug because he's very, very down. No. Before you can use the word patient to describe a person, it must be a special legal relationship or a status which he has attained by reason of his relationship between him and a doctor, a health personnel, or a hospital. So a person who is sick does not become a patient unless that legal relationship is attached. And once that legal relationship is attached, he becomes a patient, and all other legal consequences arising thereto follows. I'll be back. So, in the case of a contractual patient, where the doctor and the patient never actually undertake to or address their mind to a contractual relationship, the law implies contract. And one of the implied terms of the contract is the the duty of the healthcare provider to treat the patient with reasonable care and skill. And this is a golden thread that runs through all doctor-patient relationship. A person can also become a contractual patient of the healthcare provider while both of them are either in the church or in a party or in a social function, or even both of them meeting or not even seeing each other. For instance, when you are in the church and somebody faints, and then you are a medical doctor and the pastor calls you to come and see what is happening, immediately you take steps to treat that patient. Then the particular person has become your patient, and you have a bounden duty to treat him with reasonable care and skill. And that is the reason why we warn always that medical personnel should be very, very careful the way they hold themselves out as doctors or medical personnel. And even if you hold yourself out and assist in a church or in a social gathering or a religious gathering, you must always remember that the duty of a doctor-patient relationship already attached, and therefore you have to do the necessary follow-up and book appointment as soon as possible to see the patient physically, so that you'll be able to take the history of the patient and examine the patient physically. Otherwise, whatever comes out of that relationship, the medical personnel will be liable. The second category of patients are the one we can call statutory patients. They are statutory in the sense that they are actually not a personal patient of a healthcare provider or a doctor or any other medical personnel, but because the law says that the person is a patient of the medical personnel, even when the medical personnel is not thinking about it. An example of such patients are, for instance, the relatives of a patient under the National Health Act 2014. Now, the Act defines a patient in the terms of a user. If you go to section 63 of the Act, it defines a user of a health facility as the person receiving treatment in a health establishment, including receiving blood or blood products, or using a health care service. And the most important aspect of this definition is now. And if the person receiving treatment or using a healthcare service is below the age of majority, then the user should now include the person's parent or guardian or another person authorized by law to act on his behalf. And again, if the person who is receiving that particular treatment is incapable of making medical decision for himself, then he or the user will now include the person's spouse, that is either wife or husband. And in the absence of such a spouse, the user will now also include the person's parents, grandparents, adult, brother, sister, or another, now, or any other person authorized by law to act on his behalf. Now, the implication of this definition is that the spouse, the parents, or the relatives of the person who is receiving treatment or care directly from the hospital becomes the patient of the healthcare provider by statute and by law. So that the implication is that the implication of this is that the duty to carry the relatives of a patient along in the healthcare decision-making process is now taken from being a mere ethical duty of the medical personnel to the standard of a statutory duty, and then widens the scope of local standing against the medical personnel. Like I said, the legal implication of this definition of user, because I've already emphasized that a patient is defined in the Act, National Health Act 2014, is defined by way of a user. So the implication is that it transforms the ethical best practice of carrying the patient's relatives along in medical decision-making process from mere ethical duty to statutory legal duty. Again, this definition widens the scope of local standing in medical legal claims beyond the patient to patient's relatives even where the claim is not based on loss of a breadwinner. Usually it is only when a breadwinner is lost through medical negligence or medical malpractice that the breadwinner will now have local standing to sue the medical doctor for carelessly causing the death of his benefactor. But by this definition, since he has been included, either the spouse has been included or the parents or otherwise have been included as a user, where the main user or the main patient is not able to take a decision by himself, it gives the relatives of the patient or the spouse a clear local standing to bring action even when there is no loss of a breadwinner. Again, and finally on this point, it also legally shrinks the law of confidentiality and allows certain level of disclosure to the patient. What it means is that under certain circumstances, the doctor or the medical personnel may be justified to disclose certain confidential information of the user or the patient to his relative or spouse, because now legally and statutorily, because the patient is either underage or cannot take decision by himself, then the doctor, relying on this definition, can disclose some confidential information relating to the patient to his relatives or spouse. The next type of statutory patient, that is those who become the patient of the doctor by statutory implication and not by contract or otherwise, is gunshot victims. Gunshot victims under the Treatment and Care for Gunshot Victims Act 2017. Now, in 2017, the federal government, the National Assembly, promulgated a legislation named Compulsory Treatment and Care for Victims of Gunshot Act 2017. Now, the background to this act is that many till today, even up to till tomorrow, unless we who are lawyers are doing something about it to implement this act, the background to this act is that many Nigerians have lost their lives through no fault of theirs. Even somebody that has been hit by a stray bullet, many a time the hospitals will refuse to treat such a person unless you produce police report or unless you make some deposit. But this law has come to bring in a new paradigm shift in the law relating to treatment of gunshot victims. Now, the law provides that every hospital is to receive and treat victims of gunshot wounds with or without police clearance or police report, and with or without payment of any initial deposit. And the hospital is duty bound to report to the nearest police station within 2 hours of commencing treatment. Again, under this particular legislation, no person with a gunshot wound shall be subjected to torture or any inhuman or degrading treatment by any person or authority, including police or any other security agency. This provision reaffirms the constitutional right of every citizen to the dignity of human person. Now, the police itself may only receive a gunshot victim upon certification of fitness by Chief Medical Director of the hospital where he is receiving treatment. Again, the High Court of a state or the High Court of FCT may, in deserving cases, order that a person convicted under the Act, in addition to other penalties, to pay damages to the victim as restitution for injuries or loss sustained by the victim, and such order is enforceable by the victim or by the prosecutor on behalf of the victim. Now, every hospital is also mandated to keep adequate record of the treatment of bullet wounds victims. And the hospital that received any such gunshot victim is required to notify the family or the family members or relations of the victim as far as they may ascertain within 24 hours of becoming aware of the identity of the victim or the gunshot victim. Now, there is a penal provision that is attached to this legislation. Any authority or person or any security agency through whose omission results in unnecessary death of a gunshot victim shall be liable to imprisonment for 5 years or a fine in the sum of 500,000 naira or both. Again, a person who commits an offense under the Act, especially when the offense does not lead to death of the victim but leads to substantial physical, mental, emotional, or psychological damage, shall be liable on conviction to imprisonment for a term not more than 15 years and not less than 5 years without any option or fine. Now, what the Act has achieved is the fact that the government or the state wants to avoid the situation where people begin to lose their life just because of a gunshot wound. Even if the victim of a gunshot wound is an armed robber, we need to treat the armed robber and keep him alive for him to face the criminal prosecution process. We don't have to kill a suspected armed robber by denying him of a treatment. Even an armed robber or presumed armed robber is presumed to be innocent until proven guilty. So even if you catch him at the scene, he should be treated. He is entitled to treatment, fundamental right to life and to be treated. Then he will now follow the normal due process of trial in criminal court. And that is why the law has now mandated the hospital to report to the nearest police station within 2 hours of commencing the treatment. We shall be back. The third category of statutory patients, those who are patients by statutory implication, are persons requiring emergency treatment under Section 20 of the National Health Act 2014. I am not unmindful of the fact that my audience are actually coming from all throughout the Africa and African states. But what we know is that medical law and ethics has universal implication. It's either it is provided by a statute of the country or it is governed by the ethical requirements of the medical profession. And ethics in medical profession is of universal application. And most of the things we're saying is already covered by several declarations by the World Medical Assembly. And we're going to talk more on such declarations by World Medical Assembly in due course. But for the purpose of this particular emergency treatment, now the National Health Act Section 20 provides that on no account shall a healthcare provider deny any person of emergency treatment. Now, the full implementation of this provision is dependent on on committing 5% of the basic healthcare provision fund under Section 11 of the Act to emergency treatment to be administered by a committee to be set up by the National Council of State. What we are saying here is that Section 11 of the National Health Act 2014 makes provision for a basic healthcare provision fund, which is to be that, and it provides that at least 1% of the money in a consolidated revenue fund of the federation should be paid into this fund, and this particular fund, 50% of it should be used for primary healthcare treatments. Other percentage should be used for training of medical personnel. Other percentage should be used for facilities. But 5% of the fund is devoted to emergency treatment. So if 5% of the fund is devoted to emergency treatment, what it means is that the fund is supposed to be made available to hospitals by a committee set up for that purpose, so that where there is any need for emergency treatment, the hospital will treat and then set out its expenses by way of outgoing, by way of overhead, by way of the cost of burdens and so on and so forth, and then go and make claim, so that the hospital don't have to wait until deposit is made in case of emergency before it can treat. And section 20 already makes it an offence that for any health personnel or health care facility to deny any person of emergency treatment. It provides for a punishment of 100,000 naira or 6 months imprisonment in lieu thereof. So, but we cannot begin to imprison hospital authorities or medical doctors for not treating persons in case of emergency under this particular section, unless there is a proof of full implementation of Section 11 of National Health Act, which makes provision for the Basic Healthcare Provision Fund. Now, so far we have discussed 2 categories of patients: contractual patients and statutory patients. Now we are going to go to the third leg of classification of patients. This one, number 3, we titled it ethical patients. Until the full implementation of the provisions of Section 11 and Section 20 of the National Health Act 2014, every person who is seeking emergency treatment could only qualify as an ethical patient of the healthcare provider or healthcare personnel, because the Code of Medical Ethics in Nigeria 2008 mandates every healthcare personnel to render emergency treatment as a humanitarian duty. So it is an ethical duty of every healthcare personnel to treat persons in emergency, and that is why we call this one ethical patients, because by the ethics of the profession, every person requiring emergency treatment is a patient of the healthcare personnel. We can also identify other ethical patients. For instance, where an indigent, someone that is very poor and cannot pay for his hospital bill and is in your hospital, after the treatment he is not able to pay the fees, but the ethics of the profession say you should help treat the sick, and that the health of your patient should be your first consideration, and you have sworn to save life. Therefore, in the course of treating some patients that are very, very indigent, you as a medical personnel may address your mind to the fact that you are saving life, and such a person is a patient by the ethics of your profession. Therefore, he is your ethical patient. We may also identify those patients whom we are almost 100% sure that they are going to die, the dying patients. For instance, those who are suffering from terminal diseases, like those who are cancer patients. Most of the time when you see a cancer patient, it's as if you can presume that within some number of months or years that he's definitely going to die. Now the question is, because we know that they're going to die, should we now deny them of the necessary care and attention which they deserve? The answer is no, because the World Health Assembly Declaration of Lisbon in 1981 on the rights of patients has declared that every patient has a right to die in dignity, an extension of our constitutional right to fundamental right of human dignity. So the fact that somebody is terminally ill and we are sure he's going to die does not deny him of that fundamental right to the dignity of the human person. And that is why the Lisbon Declaration of the World Medical Assembly in 1981 has confirmed that a patient has the right, even if he is going to die, he has a right to die in dignity, and therefore he must be taken care of. Have you ever wondered why you will be in the process of procuring drug for your relative, and by the time you come back they say the person is dead? And some people will be thinking that doctor is wicked. Doctor is just showing you that this patient will need to be caring for him until he takes his last breath. Therefore, most of the time the doctors will know that the person is going to die, but we can prolong his life by giving palliative and ensuring that his dignity to the right of human person is protected and given to him. We now proceed to identify or to discuss the legal status of a patient So far, we have defined a patient. So far, we have seen the different categories of a patient. Now, I think it's time for us to zero in on addressing what is the legal status of a patient. Now, we look at the first one, which is his constitutional status. The constitution has recognized the patient in Nigeria and has given him some right. For instance, patients have fundamental right to the respect of the dignity of their human person and not to be subjected to torture or inhuman treatment under Section 34 of the Constitution of the Federal Republic of Nigeria. Again, patient's right to health is a necessary incidence of his right to life, and it is now protected under several international human rights instruments to which Nigeria is a signatory, especially in view of the universality and indivisibility of human rights. This is found in Section 33 of the 1999 Constitution. Again, patients are also entitled to fundamental right to freedom of liberty and movement. This particular right is very, very important because there are many cases where patients have been treated, and because of their inability to pay the hospital bill, the hospital have detained them. Some children who are born in a hospital and the parents were not able to pay the hospital bill has stayed there and started working, and sometimes even started school from the hospital because the parents and the children are detained by the hospital. The law is that you cannot extract your hospital bill by reason of detention of the patient, because the hospital bill is ordinary debt which can be recoverable by ordinary civil process. And for you to detain a patient is an affront against the fundamental right to liberty and freedom of movement. We also have what you can refer to as statutory status. The patient enjoys some level of status and some rights which is already protected by the statute. There is a legal duty on the part of the healthcare provider, for instance, to provide the patient with some competent care and some level of information and communication. For instance, Section 23 of the National Health Act provides that every healthcare provider or healthcare personnel has a duty to provide the patient with information on his health status. Again, the series of diagnostic procedures that the doctor is proposing. Again, the treatment options, the risk and probable cost, and the right of the patient to refuse medical treatment. All this information are entitlement of the patient under Section 23 of National Health Act. Therefore, it is duty bound on the healthcare personnel, first and foremost, after the diagnosis. May we note here that a good taking history of the patient and a good physical examination of the patient would give the medical personnel up to 75% of diagnosis, and he can make his clinical judgment based on that. And if he's sending the patient for laboratory tests or that, it is either to confirm the diagnosis or to refute the diagnosis. So, upon the conclusion of the diagnosis, the doctor or the healthcare personnel has a duty to tell the patient his health status. I have finished with you, but this is what I observe is your health status. Again, now you want to conduct a series of tests on the patient. You need to tell the patient the series of diagnostic procedures or options which you are proposing. Of course, there are different methods of diagnosis. Some are by incision, some are by ordinary observation, some are by one way or the other. Then when you now conclude the diagnosis, you need to provide the patient with treatment options. There are different ways of treating a particular disease. Some may be by surgery, some may be by ordinary medicine, some may be by injectables, some may be by abstinence from certain lifestyle, and some may be by reordering of your lifestyle. You need to provide the patient with a series of all these options, with the advantages and disadvantages of each of them, to enable the patient to be able to decide which of the option is going to accede to upon proper information. Again, and very importantly, and like an innovation in our healthcare practice, that the probable cost of treatment must be provided to the patient. This may not apply in all cases, but in cases where it is possible, the doctor has a duty to provide an idea, give an idea, a rough and rate the idea of the probable cost of the treatment. Even the right of the patient to refuse treatment is a right that is embedded in the statute. And so it's not just that you want to treat a patient. You have a duty to tell the patient that whatever I'm telling you, you have a right not to accept, because the patient is autonomous and the patient has a right to self-determination. Again, under Section 30 of the National Health Act 2014, the patient has a right to make complaint and have that complaint investigated. And the patient also have a right, the patient also have the right to have these rights to be published in conspicuous place in all health facilities, both private and public. The implication of this provision is that every hospital in Nigeria or all over Africa has a duty to publish all these rights of the patient in the conspicuous place part of the hospital, where everybody will see that it has been will see that the patient has such right whenever he steps into the hospital. We shall be back shortly. Now, the next status of the patient, which we are going to look at, is his ethical status. What is the status of the patient in medical ethics? There is also the ethical duty on the part of the healthcare providers towards the patient, especially as enunciated in the physician's oath. Physician's oath is what is referred as the Hippocratic Oath, which was modernized by the World Medical Assembly in the Declaration of Geneva 1948. Under this oath, the medical personnel is swearing to respect human life from conception, and is also swearing that the health of the patient shall be his first consideration, and is also swearing that the best interest of the patient should be his first consideration, and so on and so on and so forth. And that is where his ethical status, the ethical status of the patient now arises. Again, there is what is called International Code of Medical Ethics, or what is called Declaration of Venice 1983 by the World Medical Assembly. I've already discussed the Lisbon Declaration on the Right of the Patients of 1981. Let us now look at the status of the patient as a citizen of a particular country and a subject of international human rights law. The government of each state has a duty towards the patient to implement its international obligation under many international human rights instruments and other constitutional and statutory obligations through adequate funding of the healthcare sector. Now, having looked at all these status and the types of patients and so on and so forth, what can be done? What can we now do in order to make the status of a patient more enviable and raise it from this doldrum of lack of care and death from avoidable medical mishap everywhere in Africa? First and foremost, ethical duty there is an ethical duty on the part of medical personnel to report any dishonest or dubious practitioner. Rule 3 of the Code of Medical Ethics in Nigeria 2008 provides this. So there is what we call doctors' conspiracy of silence. There is this conspiracy of silence among medical personnel not to report each other or to hide each other from being punished or being proceeded against from their medical errors. But it is unethical for any professional in the medical profession not to report any dishonest or dubious practitioner. Again, healthcare facilities should implement relevant provisions of the National Health Act that concern them. For instance, publication of the rights of patients in conspicuous places, including the right to lay complaints and to be investigated. Again, many doctors and many medical personnel who are public servants, employees of federal government, state government, or local government, are still practicing as private medical practitioners, which is quite contrary to the constitutional provision under Schedule 5 of the Constitution, that is Code of Conduct for Public Officers, which prohibit any public officer from practicing any trade, business or profession except farming. Again, there is urgent need for attitudinal change on the part of every medical personnel. There is need for an increased empathy, sympathy, communication, and unconditional positive regard for their patients. This is the provision of the Code of Medical Ethics in Nigeria 2018. There should also be expansive approach to the relationship between patients so as to involve family members in medical decision-making process. And then mainstreaming. We need to mainstream the teaching of medical law and ethics in the syllabus of medical in the syllabus for the training of medical students. It may interest you to note that many or all medical personnel in Africa pass through the medical school without having the opportunity of studying medical law and ethics. I have observed that whenever the medical students in Nigeria go to Geneva, going to Geneva is when they go to inducted to take their Hippocratic oath to be registered as a medical doctors. It is upon the taking of that oath and upon induction and registration that they are handed over for the first time in their life a copy of the Code of Medical Ethics in Nigeria. So unless the teaching of medical law and ethics is mainstreamed into the syllabus for training of medical students, and even by extension into the syllabus of teaching law students, it will be very, very difficult for us to have a widened awareness of the rights of the patients. Again, the patients themselves have a duty. The patients in Africa, coming from underdeveloped background, we should wake up. We should wake up and be alert to our medical and health rights. We should demand both professional accountability and international best practice from healthcare providers. How do we achieve this? Those of us that are lawyers or law students should join the advocacy, should set up NGOs, should join us at our Lifeline Center for Medical and Health Rights Advocacy. Let us promote awareness and advocacy and extract professional accountability by enforcement and even by negotiation or by whichever means, or by use of ADR, from medical, so that we can avoid death and injury that are avoidable medical mishap. We have so much duty to do, especially as legal practitioners. We have a duty to the society, and to whom much is given, much is expected. It is unfortunate that we have so many lawyers, more than 120,000 lawyers as at 2017, and yet many of these avoidable medical mishap is going on. Do you know that these medical students, these medical personnel, when they go abroad, they practice according to international best practice, but when they come back to Nigeria and to African countries which are so much undeveloped, they capitalize on our corporate ignorance, our cultural inertia, our religious belief that make us not to ask questions. We must always probe. We must always ask questions. When our relative or ourselves are in the hospital, we should be able to ask questions. We should be able to probe. When you don't understand, ask questions. By way of conclusion, I want to appreciate all of us for being so much attentive and for following us along this almost very prolix lecture. I want to congratulate each and every one of us, and I want to say that I'm excited that there is a body like this, African Law Students Association. It shows that the legal profession in Africa, especially the legal profession in the medical legal field, has a very bright future in Africa. I'm always here, willing, ready, and able to attend to your question now after I finish my presentation. And apart from that, this relationship has come to stay, and it shall continue. God bless you. Yes, I just received a question now on the question whether a medical doctor who is assisting gratuitously in a church or in a social gathering will be legally liable? That's the essence of that question. The legal implication on the medical doctor or personnel who is assisting gratuitously in a church or in a social gathering. Now, the law is that once there is a request and undertaking, a request by a patient and undertaking by the medical personnel to treat, that doctor-patient relationship is established. Now, in obvious cases, majority of cases, there will always be requests by the patient. But in some cases, like emergency cases, like where the patient has fainted and require urgent attention, there is no need for a request, but there is always need for undertaking to treat. So where a doctor arrives in accident scene, or somebody faints in a hospital, or someone faints in a church or in a party, and the doctor is called to come and assist, by taking steps to touch and treat the patient, that golden rule to treat the patient with reasonable care and skill attaches. If you are not the medical personnel and you are assisting with your native intelligence and traditional wisdom, there are really no legal liability on you, because you are just assisting. But remember that the medical personnel, even though he's assisting, has held himself out to the whole world as a competent professional, and so the law will hold him liable if he acts negligently in the treatment of the patient, whether the patient has paid fees or whether he's just assisting gratuitously. And remember that in medical law and ethics, where the patient did not pay fee, that does not mean that there is no doctor-patient relationship, because in law, in medical law and ethics, the submission of your body to the medical personnel is sufficient consideration in the contract for medical service. Thank you. Now this question says, what happens if the patient is unable to consent to medical diagnosis because of unconsciousness? There is an exception to the general rule of consent. One of the exceptions is where in cases of emergency or in cases of necessity. Now, emergency comes where there is need to act to save life. Necessity comes where a reasonable adult who ordinarily has the capacity to consent suddenly loses the ability to consent, like the case of unconsciousness. In that case, the doctor may go ahead to treat, to assist the patient based on the doctrine of necessity. Thank you. This question is saying that I should recommend a short course in medical malpractice for lawyers. First and foremost, yes. I was asking Chinyere whether she attended the course or the training we organized for law school students. Last year, we organized a webinar like this for some law students, and if this association agrees and organize it, I am willing, able, and ready to give a short training and short course, either by way of webinar or by physical presence, to you people. Once you are officers or officials, organize it and get in touch with me. Then the other question say, what are the modalities for joining the Lifeline Center for Medical and Health Rights Advocacy? Well, you discuss with, if I discuss with your officials, I can post our form to your platform. Since people are all over the world, I can post the form and then you fill the form and return to us, and we'll take it there. We need you all over Africa and all over the world, because the work to be done is really enormous. Thank you. This question is saying whether an individual can establish a hospital or an hospital only for female gender or for one particular gender, thus denying other gender from being employed or from being patient in the hospital. It is a free world. It is a free world. And if somebody wants to set up a gender-based hospital, of course, there is no law that says you should not set up a gender-based. It's only where there is discrimination. Now, when we talk of discrimination between gender, it does not really apply to individual entrepreneurs, so to say. You can set up a business and say you want to employ only ladies, or set up a hospital and say you want to employ only ladies. Yes, even a government hospital, there could be a special hospital for a particular gender. There in this country, we have women and children hospital. We have eye center for only those who are suffering from eye problem. We have cancer centers for those who are suffering from only cancer. So if you set up a particular hospital and say that it is for this purpose, I don't think it's discrimination against Section 42 of the Constitution. Comfort is asking why I keep addressing all of us as gentlemen, even when we have ladies in our midst. Of course, I don't know what applies in other countries of Africa, but in Nigeria and the generality of the world, I know that all lawyers are gentlemen, and even lawyers to be. If you have not been called to the bar, you are a lawyer to be. Sorry, I was interrupted by an incoming call. So I was saying that all over the world and in Nigeria particularly, every member of the legal profession is a gentleman, and so we can only differentiate between gentlemen in trousers and gentlemen in skirts. But the base and the common denominator is that both ladies and men are gentlemen at the bar. Thank you. This is a very funny question. I know it is for just a comic relief. Thank you, Comfort. This question is saying whether there is any legal relationship which exists between a patient and a pharmacist before treatment from the hospital. That is, when a person goes to buy drug directly from the pharmacist before seeing a medical doctor. Yes, there's a legal relationship. First and foremost, when you come to a pharmacy, there are different types of drugs. Some drugs are called over-the-counter drugs, that is OTC drugs. So for over-the-counter drugs, anybody can walk into the pharmacy and request for such drug, and the pharmacist will be able to sell the drug directly to you, because the professionals and the law say that yes, this can be dispensed to anybody without a doctor's prescription. Now, but there are other drugs that are not an over-the-counter drug. They are maybe drug in the dangerous drug list, the list of dangerous drugs under Dangerous Drugs Act. So these drugs cannot be dispensed to any person unless with doctor's prescription. So where a pharmacy dispenses drugs that are not over the counter to an individual and it results in any harmful effect, then the pharmacist will be liable. He will be liable to the person, and he will be liable to his profession, and he will also be liable criminally. Again, a pharmacist that is dispensing drug is supposed to explain to the person that is receiving the drug, the side effect of the drug and the dosage of the drug. If he makes mistake or omit to explain the side effects of the drug and anything comes out of it, he will be liable. Thank you. This question is saying that during this pandemic, a lot of countries have passed laws granting immunity to medical personnel when going about their work, especially treating the pandemic patients. But the person is yet to see any such laws in Africa. Is it because of the low level of prevalence in this country? Now, these type of laws which are passed in order to give immunity to medical personnel are called Good Samaritan laws. They are laws that are promulgated in order to help the medical personnel to own up and to come out to assist people in time of emergency and in time of a pandemic like this. That if you enforce the law strictly against medical personnel, they will run away, they won't show up, and so there will be more deaths than would have been expected. But some of these Good Samaritan laws are promulgated to encourage doctors to, especially in emergency situations. So if there are none or not many of such laws in Africa yet, it is because, like you suggested, because of the number of infection has been very, very low, and our healthcare personnel and healthcare facility has not been overstretched as it has been the case in many developed countries. Thank you. So, those good Samaritan laws that are passed in those countries in order to encourage personnel to come out and treat pandemic patients is their last-ditch effort to ensure that because of many deaths and because of many infections of medical personnel, that medical personnel don't shy away or run away from assisting those who are infected.